So, welcome. We are covering the Sherrone Moore hearing. The defence have asked or submitted a motion for a evidentiary hearing because they do not believe that the processes were followed correctly by law enforcement and the prosecution.
In this case, the picture that she painted was inaccurate, not supported by the facts of the person who was present, not to mention the omission of the employment relationship. There was communications that were legitimate. And if the communications were legitimate, it is not harassment. It's not harassment, it's not stalking. Count one, home invasion in the third degree, states that it is breaking and entering with the intent to commit a misdemeanor, and in this situation with the intent to stalk. So in order for home invasion in the third degree to have survive a probable cause analysis, relying on the act's post employer-employee relationship isn't good enough. They have to show that he went into her apartment with the intent to stalk her, which means there had to have been predicate acts of stalking prior to entering the apartment. If they are now saying that the only acts that we are relying on are the acts post leaving the apartment, the home invasion fails. And it should fail.
The falsity really comes in the way that it was sworn at. It at worst is false and an outright lie. Or at best, it is misleading. And particularly when it talks about the 10 to 12 phone calls and text messages, there's not one mention of the fact that those to which they could determine were work related. There's not a mention. That is a huge, in this court's perspective, that's a huge omission. Because immediately afterwards, again, there's like a statement from the complainant about these 12 calls, making them seem as though they are somehow related to some type of harassing behavior because there's nothing on the other side to say what it may be. And then the immediate statement afterwards is a text message that came after the incident or later on the 10th, after the issue regarding the complainant's home. Frankly, I think that was intentional. I think it was intentional to place a context without saying. Give the court a context. If you look at the very beginning, that he's this monster, he's this person that's been doing all of these things, been harassing her for months. You lead that down into all of a sudden this day comes along, or the 8th December comes along. There are these 10 to 12 phone calls, which one might presume would be a continuation of harassment, but we now know are not any type of harassment. And then the December 10th. I don't believe a lot of times in coincidence. I don't believe that things happen all the time by accident. I agree. I think that was an intentional misdirection to the court.
Okay, so there will now be an evidentiary hearing on the 2nd of March. Judge is not happy. He believes that the lead investigator intentionally misled the court to prosecute Sherrone Moore. So they will have an evidentiary hearing on the 2nd, and it will be determined whether the court was misled or not. So even if the court was misled, the state can still resubmit the charges but the defense don't believe that there would be charges to submit. But yeah, the judge is very, very clear. He is not happy that, and it's not normal for a judge to say that he believes the lead detective or anybody misled the court, and in this case, he believes they did, because at the time, the victim, who was Sherrone Moore's assistant, some of those calls were work related because they were arranging to go into the Citrus Bowl where Michigan were playing Texas. So the argument was a lot of these calls and text messages were not harassment as the state is saying. These calls were work related, and because of that, he shouldn't be here. So I don't know what's going to happen in the future, but I'm still looking forward to covering this case, see what happens, whether Sherrone does still get prosecuted or not. So yeah, we'll try and cover that on the second to see what happens.